the most landmark judgment delivered by the Supreme Court or the apex court was Kesavananda Bharti vs.State of Kerala. So, in this particular leading case, it provided definite answer to the issue of whether the power of Parliament to amend the Constitution is absolute and unqualified. The decision in Kesavananda Bharti case laid down the basic structure, doctrine of the Indian Constitution. So, in the very important leading case, Kesavananda Bharti vs. State of Kerala, it was held in immense significance for several reasons, one of them being that it was held by the largest ever bench at that time constituted by the Supreme Court of India, comprising 13 judges of the Supreme Court, headed by the then Chief Justice of India, Justice Y.P. Chandrachud, and the very background of the Kesavananda Bharti case that you would like to discuss. That in the judgment of Goloknath vs. State of Punjab in 1967, the Supreme Court held the Parliament does not have the power to amend the Part 3 of the fundamental rights of the Constitution, as fundamental rights are the most significant part and the sacred portion of the Constitution of India. So, in this particular case, the Kerala Land Reforms Amendment Act of 1969 and 1971 was challenged, and in particular the constitutionality of 24th Constitutional Amendment of 1971 and the 25th Constitutional Amendment Act of 1971, which are both challenged. So it was held that any amendment made under Article 368 of the Constitution would be treated as an exception under Article 13, which defines the very term law and its scope. As a result, in order to counteract this effect, the Parliament annexed Clause 4 to Article 13 of the Constitution so that no amendment would have an effect under Article 13. So, following the landmark judgment of Goloknath vs. State of Punjab, the Parliament passed a series of amendments to overturn the Goloknath case judgment. So the 24th Constitutional Amendment Act of 1971 affirmed the power of the Parliament to amend any part of the Constitution, including Part 3 and the fundamental rights, and made it mandatory for the President to give assent to a constitutional amendment bill. And as under the 25th Constitutional Amendment Act of 1972, which curtailed the right to property as enshrined under Article 19, Clause 1, Subclass F, and Article 31, right to property, empowering the government to acquire private property for public use and exchange for compensation decided by Parliament rather than by the courts. The Parliament included the Kerala Land Reforms Amendment Act 1969 and also the Kerala Land Reforms Amendment Act 1971 into the 9th schedule of the Constitution. So you would like to discuss the very facts relating to this important leading case. So the very petitioner His Holiness Sripat Galvaharu Kesavananda Bharti, the lead petitioner in this case was the leader of Ednir Mutt, a religious sect in Kerala's Kasaragod district. Kesavananda Bharti had some plots of land in the sect that he owned in his name. So the Kerala state government enacted the Land Reforms Amendment Act in 1969, which conferred upon the government the right to acquire some of the land owned by Ednir Mutt, of which Kesavananda Bharti was the leader. And particularly in 1970, Kesavananda Bharti filed a writ petition in the Supreme Court under Article 32 of the Constitution to enforce his rights guaranteed by Article 25, which can pass the right to practice and propagate religion, and Article 26, which guarantees the right to administer religious affairs. Also relating to Article 14, which provides right to equality, and Article 19, Clause 1, Subclause F, which provides freedom to acquire property, and Article 31, which provides for compulsory acquisition of property or right to property. While the very petition was still being heard by the apex court, in between the Kerala government passed another amendment act, and that was Kerala Land Reforms Amendment Act 1971. So the issues before the apex court was relating to 24th and 25th Constitutional Amendment Acts of 1971 and 72, and also relating to Article 368 of Parliament's amending power. So, whether 24th Constitutional Amendment Act 1971 is constitutionally valid, whether the 25th Constitutional Amendment Act 1972 is constitutionally valid, what is the extent to which the Parliament can exercise its power to amend the Constitution as per the provisions laid down by the Constitution itself under Article 368. So the very contention from both sides that we would like to discuss as regarding the very contention of the petitioner Kesavananda Bharti as presented by his learned counselor. So the petitioner argued in Kesavananda Bharti vs. State of Kerala that because Parliament has limited power to amend the Constitution, it cannot do so in an arbitrary and unrestrained way. The petitioner referred to the statement given by Justice Mudalkar in the case of Sajan Singh vs. State of Rajasthan in 1964, when it was said that Parliament cannot exercise its power to amend the Constitution by modifying its basic structure. The petitioner sought protection and rights of his property as provided under the fundamental rights under Article 19, Clause 1, Subclause F of the Part 3 of the Fundamental Rights. It was contended by the petitioner that the 24th and 25th Constitutional Amendments of 1971 and 72 violated the fundamental rights guaranteed under Article 19, Clause 1, Subclause A of Part 3 relating to fundamental rights of the Indian Constitution, while the very contention from the respondent, the Kerala government contended that the Parliament's power to amend the Constitution is absolute and unlimited. This argument was based on a fundamental principle of the Indian legal system, namely the supremacy of Parliament, as made reference that the case of Beruberi Union case of 1960. Furthermore, the state argued that in order to fulfill the socio-economic obligations guaranteed to the people by the Constitution in the preamble, it is essential that the Parliament's authority be unrestricted. So, the very decision that the judgment that we would like to discuss, the 13th judgment of the Supreme Court in Kesavananda Bharti case 1973 by a majority of 7-6 held that Parliament has the authority to amend any clause of the Constitution as long as the amendment does not violate the basic structure of the Constitution. Despite writing different opinions, the minority bench did not concede that there are certain provisions that are fundamental. They were also hesitant to grant Parliament complete and unfettered authority to amend the Constitution. The Apex Court upheld the entire 24th Constitutional Amendment Act 1971, but considered the first part of the 25th Constitutional Amendment Act of 1970 to be ultra-vires, and the second part, the court using social engineering and balance in the interest of both the litigants, determined that neither the Parliament nor the Supreme Court has the authority to make any change to the basic structure of the Constitution, nor can it withdraw the mandate to create a welfare state and a fair society. The basic structure doctrine was thus formulated in the Kesavananda Bharti case, which implied that although the Parliament has the authority to amend the entire Constitution, they must do so in a way that does not contradict the very features so fundamental to the Constitution that it would be spiritless without them. So, what are the very contentions relating to basic structure doctrine? So, the fundamental features of the Constitution would be considered as the basic structure of the Constitution, which would include supremacy of the Constitution, republican and democratic form of government, secular character of the Constitution, separation of powers among the legislature, executive and judiciary. So also the federal character of the Constitution. In simple words, the basic structure doctrine is a rule that states that certain provisions of the Constitution that are so fundamental to the values, objectives and soul of the Constitution cannot be amended under any circumstances by the legislature, and that is the Parliament of India. So now we would like to conclude the very landmark judgment that we have discussed is relating to Kesavananda Bharti vs. State of Kerala. So, here it was exactly In this case, it was believed that by issuing this decision or judgment, the court had protected Indian democracy for which our revered ancestors had fought so valiantly. The most significant result of the freedom struggle was democracy, which gave ordinary citizens who were most oppressed the power and rights. If the bench had ruled differently, the rights and authority for which our esteemed freedom fighters battled so valiantly would have withered away. Thus, this momentous judgment upheld the constitutional values, strengthened the foundation of the Constitution, and restored the confidence of the common people in the judiciary and in a democracy. The Kesavananda Bharti decision forms the most powerful and binding precedent in the history of Indian Constitution. The basic structure doctrine is used to determine the constitutional validity of any amendment or act of Parliament. According to former Chief Justice of India, S.M. Sikri, the following elements constitute the basic structure of the Constitution, or are the fundamental features of the Constitution under which we could discuss, such as the very preamble itself. The fundamental rights as provided under Part 3 of the Constitution, including judicial review, as provided under Article 32 and Article 226 of the Constitution in respect to the Supreme Court or Apex Court and the High Courts in different states, and the very republican and democratic character of the government as provided under the Constitution of India, and also the very provision relating to secularism, which was inserted into the preamble of the Constitution under the 42nd Constitutional Amendment Act of 1976. Further, the very distribution and division of power in between the union and states, which represents the federal character and spirit of the Constitution, besides the division of power among the three different organs of the government and state, that is, the executive, legislature, and judiciary, or would be considered as the basic structure of the Constitution.